Good day and a warm welcome to panelists and audience from across the globe. Over almost 200 have registered today to today's webinar's discussion on the advisory opinion on climate change, the legal bedrock of state responsibility, looking specifically at the Inter-American Court of Human Rights opinion on the climate emergency and human rights. My name is Danielle Yang, adjunct senior research fellow and lead on climate change foreign policy at the Center for International Law, National University of Singapore. Today's webinar comes at the end of the month, which has witnessed the release of two historic groundbreaking advisory opinions by two international tribunals relating to climate change. The first being the opinion of the Inter-American Court of Human Rights on Climate Emergency and Human Rights, issued on the 3rd of July, which is the subject of today's webinar. The second, the advisory opinion on the International Court of Justice on the obligations of states in respect of climate change in response to submissions to a request from the UN General Assembly. And that was issued on the 23rd of July. And that will be the subject of the webinar 2 in this series. These, together with the previous IACtHR advisory opinion on climate change of the oceans, represent extraordinarily significant legal developments in the fight against climate change. The advisory opinion that was the subject of today's discussion is a joint request from Chile and Colombia, posited a simple yet profound question as to the legal obligations of states in responding to the climate emergency under international law. The ensuing advisory opinion can be said to fundamentally redefine the relationship between human rights and our changing environment and our changing climate, establishing for the first time a legally recognized right to a stable climate, declaring climate change as a human rights emergency, requiring immediate and comprehensive action from every nation in the Americas. The ruling has been hailed by UN human rights experts as a transformative step in advising climate justice and environmental protection through the lens of international human rights law. The rich tableau of issues addressed in the advisory opinion ranges from the nature of the right to healthy and climate, the legal personality of nature, the obligation not to create irreversible damage to the climate and global environment as a use codes and norms, among many, many others. We are very, what then are the implications of this decision for states, for corporates, for peoples and communities in civil society? With that, I'm delighted to welcome our expert panelists to today's dialogue to unpack the key aspects of this opinion, both in terms of substance and process, as well as its broader implications and significance. Our panelists today include, first up, Catalina Fernandez-Carter, who's the head of the Department of Multilateral Human Rights Protection Systems and Bilateral Affairs at the Ministry of Foreign Affairs. She will speak to us by a pre-recorded message, given the time zone differences. We will also have Dr. Nilofer Oral, who's the Director of the Center for International Law, Professor Helene Taruja, Professor of Public International Law at the Aix-Marseille University, as well as a visiting research professor here at the CIL. Dr. Charampalas Giannopoulos, whom I have frequently referred to just as Harry, a senior research fellow at the CIL International Economic Law and Policy Program, and last of all, Ms. Elizabeth Wu, legal and consultant with Client Earth. In the interest of time, I will not be reading out their bios, but I would certainly invite the audience to read them on the Eventfly. So first of all, I will request for the playing of the message from Ms. Catalina, who sets the stage for our discussions today. She led very much Chile's case in this matter, and her views will be extremely important and significant for our discussions. So thanks. May I ask my colleagues to play her recorded message? Thank you.
Hello, everyone. I'm so happy to be joining this event, even if through a pre-recorded message. Thanks so much, Danielle, for inviting me. And I'm sorry that I cannot be at the same time that you because of the time difference. But I'm so happy to see that these advisory proceedings are being discussed all over the world, even so far away from Latin America. So I think this already addresses one of the points that I want to mention in my remarks on how this decision may be a powerful tool for people all around the world. So one of the first questions that I was asked to address was, why did we decide to make this request to the Inter-American Court of Human Rights? Why did Chile and Colombia make that decision? And of course, I cannot take credit for that decision, but I was part of the process, the final process in drafting and all the hearings that we had in these proceedings. And I think there are many reasons that may explain why the perspective of a human rights court was important, especially considering the existence of two other proceedings before the International Court of Justice and the International Tribunal for the Law of the Sea. But I think an important point that made this decision, or this request, I'm sorry, important was the fact that we were dealing with a human rights court that was specifically going to address human rights issues. And of course, we know that the International Court of Justice request also had human rights questions. But if that is a court that is not specialized on human rights and does not have, as the Inter-American Court does, a rich case law on human rights, including economic, social, cultural, and environmental rights, and that has the experience of working in different cases that address these topics. And we thought that was a very important consideration, also taking into account the great impact that the crisis has on human rights, and that needed to be addressed. But also more generally, I think the language of human rights has such a mobilizing effect that other law language may not have. So when people are talking about the right to life, the right to personal integrity, or the impact of the crisis on different groups and situations of vulnerability, this language that may be used by civil society actors, by academia, by others, to push for states to be more ambitious in the measures that they take to address the crisis. And this is, I guess, particularly important in the case of America, because in the decisions, the judgments, and the advisory opinions of the Inter-American Court of Human Rights have had, in other cases, dealing both with civil and political, but also with economic, social, cultural, and environmental rights, they have had a significant impact on at least Latin American jurisdictions. So it's not rare for advisory opinions or decisions in contentious cases of the court to be used by lawyers, by judges in their decisions, and to, again, this language to be used to help national jurisdictions to move forward, to be, for the judges to consider these standards that have been established by the court in new cases and addressing new challenges. So in a way, the use of human rights may be an important tool to ensure that this traditional problem of lack of enforcement of international law may be somehow remediated with reference to domestic law, and how domestic tribunals and domestic politicians use international law to justify their decisions locally. And also the fact that we're dealing with a court that has, as a human rights tribunal, the possibility for civil society, for victims, for indigenous communities, for academia, for scientists, for so many to participate, which is something that we know it's not possible for the International Court of Justice, was so important. I had the privilege of being in the hearings both in Barbados and Brazil, and the possibility for victims of the crisis to be directly before international court is not something that is just symbolic. I think it's an act of reparation itself. And we thought, or I think, the possibility of a tribunal giving the voice to people that have never been heard by international actors is so relevant. And then, because I have, again, very limited time, just to draw upon some of the things that I think are relevant of the decision, is first how Latin America is a region that has had a very limited impact on the existence of the crisis, of the emergency, as we called it in the request, but has suffered tremendously from its impact. And I think this is something that could also be said of the Pacific Islands. There's so many other regions in the world whose contribution to the emergency is very limited, but the impacts are not proportional to this. And I think in this point, the court addresses two issues that I think are very relevant. First is the duty to cooperate, trying to establish more concrete elements of this duty to cooperate by states that are most responsible or that have more economic resources, or in helping and cooperating with other countries that are that have suffered all the impacts of the crisis. And I think this is very important, even in the region. Of course, if this could be applied to other big polluters, it would be even more important. But I think even in the region, where we have a few important countries that are responsible for a significant amount of emissions, is as important. I hope it will influence the climate negotiations. And the second, on this idea that most Latin American countries have had a reduced responsibility in the crisis, is the importance that the court gives to the question of adaptation. Because I know the discussion on emissions, again, is, for instance, how Chile can contribute and reduce its emissions is of course important, but would probably not significantly change the situation. But countries such as Chile or Colombia still have a very significant obligation with regards to adaptation, to making sure that their communities and population are as protected from the crisis as possible. And that requires establishing a series of plans and programs to adapt as far as possible. Of course, we know adaptation has limits, but to the fact that our country has had a limited impact does not eliminate the country's responsibility and any state's responsibility to protect the human rights of its population and to take, in this case, measures to address as far as possible the impacts of the crisis. And the third point and last point that I would like to address is how the court uses the language of the Escazú Agreement to impose general obligations upon all states, at least all states members to the Inter-American Convention on Human Rights, or signatories of the American Declaration of Human Rights. Because the Escazú Agreement, which Chile has ratified, Colombia as well, but not all countries in America, and of course not all countries in the world, establishes so many important procedural and information obligations for states that are crucial to address the crisis. So Escazú sets a higher standard, which the court in some way transforms into universal standards, which derive from rights protected under the convention. So one could argue that if through the right to life, through the right to personal integrity, through other social and economical and cultural rights, etc., you could also establish these very substantive and, procedural, but very important obligations to access information, to access to remedies, to possibility of claiming before courts, etc. I think that will definitely set up a higher standards for countries in the region, and hopefully will influence other regions around the world. And I think it's so important that all around the world this advisory opinion is being discussed. And of course, we don't need to agree with every single aspect of it. The Inter-American Court is famous for its very broad-ranging just judgments and decisions, advisory opinions as well. And I think there are certain points of the opinion that could be discussed. But even the International Court of Justice mentioned the advisory opinion, did not discuss upon it. But the fact that all these three proceedings before the IACtHR, the ICJ, and the Inter-American Court are starting this conversation that will, I hope, influence both the environmental discussions, but also the national, as I mentioned, national jurisdictions and national civil society actors to request and demand their countries to be more active in this crisis. And I hope this limited contribution of human rights in Latin America can also be relevant for this discussion. And I'm out of time, so thank you so much for inviting me, and I hope you have a very fruitful discussion.
Well, thank you very much to Catalina for generously providing her views, which are really rich, even though it was a previews, in setting up the background, the thinking behind the decision to request for this opinion, and also the history and background of the court in that region, that would explain perhaps the approach that was taken by the court in the advisory opinion. Before I turn to Helene to start off our conversation, I just wanted to remind and invite and in fact encourage the audience to please use the Q&A function to add your questions, to add your comments. We want this to be an interactive session, and we would very much be keen and interested to welcome views on the chat function that the panelists can then address as part of this conversation. So with that, Helene, can I turn to you? Catalina has, really raised a number of very interesting points. The one of which struck me was the sort of the emotive mobilizing impact of the language of human rights. And the second which struck me was really the background she talked about. I won't call it judicial activism as such, but certainly a very adventurous spirit on the part of the courts and really the familiarity and in fact a frequent device using international law to justify, to mobilize, to move domestic legislation, policies, and measures, and even domestic courts. Can I turn to you? I mean, you're very familiar. You've looked at the Inter-American Convention of Human Rights. What are your observations? Can you share on the court's reasoning and perhaps legal innovations in this regard?
Thank you. Thank you, Daniel, for organizing this. And I'm very happy both to share the panel with wonderful colleagues, but also, as Catalina said, to talk about the Inter-American Court advisory opinion from Singapore. And for me, it's really the sense of universality of the message conveyed by the Inter-American Court. So a lot of things I'm going to say, because it's a very long advisory opinion, so I cannot discuss about all the aspects. But I would like to also echo what Catalina said, and I will divide my intervention in three general parts, I would say. So first, and I hope I will reply to your question, Daniel, the procedural aspects of this advisory opinion. So as it was explained by Catalina, it's an advisory opinion that was requested by two states, so Chile and Colombia, in January 2023. So in general, the Inter-American Court takes 1 year or 14, 15 months to deliver an advisory opinion, but here it was a bit longer due to the very large number of contribution submission, and I will go back to this point. So it was requested by states based on Article 64 of the American Convention on Human Rights, and it's an important point because there was a previous advisory opinion. So it's not the first advisory opinion dealing with environment and human rights. Advisory opinion 23 that was delivered in 2017, and it was already requested by a state. So this is an important point to keep in mind, especially because I will come back to the implementation aspect and what would be the next step for Latin American countries. So that's the first element in terms of procedure. The second element, that I echo what Catalina just said, it's really, really, really exceptional in terms of number of briefs, submission, number of delegations showing up before the Inter-American Court of Human Rights. And I agree with what Catalina said about the sort of act of recognition of voices from different perspectives, scientific perspectives, special rapporteurs, civil society, legal clinics, academics, and so on and so forth. So in terms of statistics and figures, the court received almost 300 briefs, 2 public hearings, and more than 180 delegations intervened before the Inter-American Court. This is unprecedented. So it's really send also the signal that it's not only a sort of regional question or Latin American question, but a lot of NGOs, colleagues, UN special rapporteurs, and so on, intervened in this procedure, so from different perspectives, and bringing in the conversation not only Latin American perspective, but also international law and more universal perspective. That's the second element. In terms of procedure, I would like also to stress what the court said on the admissibility of the advisory opinion. Of course, there was no issue of admissibility because the court said it's a human rights advisory opinion. So the questions are based on the American Convention, and especially right to life, prohibition of torture, and so on, but also the Protocol of San Salvador dealing with economic, social, and cultural rights, which is true, of course. But if you read the advisory opinion, it's also true that the court goes far beyond what the American Convention says or what the Protocol of San Salvador says, because the Protocol of San Salvador, for instance, indeed has a provision on right to a healthy environment, but this provision, legally speaking, is not justiciable. So the court said formally, yes, I mean, it's an advisory opinion dealing with the American Convention and the protocol, but actually it goes far beyond. And the Inter-American Court also insisted on the fact that it's not only about the American Convention, it's not only about the Protocol of San Salvador, but it's also about the interpretation of the Organization of American States Charter and the Inter-American Democratic Charter. And it's very important because it was her way to say that actually this advisory opinion is not only addressed to parties to the American Convention, but it is addressed to all members of the Organization of American States, which means included the US and Canada, not party to the American Convention. So it's very important. And in all the paragraphs, or almost all the paragraphs, the court insisted on the fact that what she's saying, it's not only for Latin American countries, it's not only for Chile and Colombia, but it's for all. It's a sort of authoritative interpretation of international obligations of member states of the Organization of American States. So I will probably, if I have time, go back to this element. And it also has to do with what the court stressed in terms of sources of interpretation and method of interpretation. For human rights lawyers, I mean, it's quite common to have this in judgment and case law of the Inter-American Court, but the court insists here that she's not only going to use the American Convention or the Protocol of San Salvador on economic, social, and cultural rights, but she's going to use what she called the international corpus juris. So everything that has to do with the question raised by the states. So environmental law instruments, soft law, hard law, regional instrument, domestic instrument, international instrument, customary norms, and so on and so forth. Even the case law, and I was very proud of this, even the case law of the Human Rights Committee and our Billy and others versus Australia decision. And this is very important because in general, states do not like when the Inter-American Court does use this sort of external sources. In general, states insist on the fact that the material jurisdiction of the court is limited to the American Convention. So that's why we have several paragraphs when the court said, yes, indeed, the advisory opinion is about the American Convention, but this cannot be interpreted without a strong analysis of environmental law instruments, the Paris Agreement, and law of the sea, and so on and so forth. So it's also a very interesting point because, again, I mean, the court is aware that there's pushback by states. And again, they do not like, in general, when the court gives the impression to go beyond the material boundaries of its jurisdiction. Two final points on the procedure. First, the court actually totally, maybe not totally, but radically reframes the question raised by the states. So she's not bound by the way Chile and Colombia raised the question. And she said, yeah, there were many, many questions and sub-questions and so on. So based on its jurisprudence, the courts decided to reframe the questions and to actually insist on three aspects: substantive obligations of the state in relation with climate change and human rights, procedural rights and procedural obligation in relation to democracy. I will go back to this point. And then the third element is a focus on the most impacted groups, so indigenous people, environmental defenders, peasants community, and so on and so forth. And finally, the court insisted, and I think it's very important for all of us, international lawyers, academics, practitioners, and so on. The court insisted on the fact that what we are talking about, it's really, and I'm quoting the court, a polycrisis that needs to be and we need to break the silos. And indeed, it's a sort of invitation not to have specific focus from human rights perspective or climate change perspective or environmental law perspective, but to have this sort of global and integrated conversation. And that's exactly what CIAL is doing actually with these three webinars. And that's why I'm very, very happy and very proud of being part of this conversation. So that's for the procedural aspect I wanted to highlight. Now on the substance, I have to say, as a human rights lawyer, and indeed I'm quite familiar with the case law of the Inter-American Court of Human Rights, a lot were taken from its previous jurisprudence, advisory opinion, but also case law. So for instance, advisory opinion 23, I already mentioned on environment and human rights. The advisory opinion was delivered in 2017, but also previous jurisprudence on the regime of states' obligations, previous jurisprudence on access to information when dealing with environmental information in Claude Reyes versus Chile, for instance, or more recently, another very important cases versus Peru, La Oroya versus Peru. Case law on rights of indigenous people, case law on non-discrimination as a norm of jus cogens, and so on and so forth. So, and I'm using the vocabulary of very familiar to Nilufer. So a large part of the advisory opinion is a sort of codification of what the Inter-American Court has already said in its judgments, but also in its advisory opinion. But other parts for me are indeed a sort of progressive development of a very specific aspect. And I'm just mentioning maybe 5 of them. I'm sure there are many others, but maybe from my perspective, and really I was very discretionary when I chose these elements, I will pick up 5 of these elements for me that are quite progressive development. Obligation of cooperation, that was mentioned by Catalina. It's true, we do not have the court tried to say that indeed we have something on the American Convention, but it's not for me really true. There's nothing really substantive in terms of obligation of cooperation of states. So the court spent many paragraphs to insist on the legal ground of this obligation to cooperate when it's about climate emergency, but also the content. So it's not only a theoretical discussion on the legal recognition of this obligation to cooperate, but she also gave a sort of roadmap or a very precise content of this obligation of cooperation. So it's really important because it's, for me, a sort of dark point in human rights and in human rights law. We do not have a lot on obligation of cooperation. We all agree that states should cooperate, but because international human rights law is still very state-centric and territory-centric, we do not have a lot of legal reasoning on this. And I really appreciate the effort of the Inter-American Court to try to build something. It's still in progress, but I mean, the paragraphs on this are very interesting. The other element I thought and I found very interesting in the decision is what the court said about the involvement of all the branches of states when we talk about climate emergency. So not only the executive, not only the legislative, but also the judiciary. And there are many very interesting things on the role of the judiciary, so climate justice, and the way tribunals should accept and therefore modify the procedural rules when dealing with individual claims, but also when dealing with collective claims. So she has a lot of developments on evidence, legal actions, and so on and so forth. And it's interesting because we know that even before human rights regional bodies or UN bodies, we have these legal and procedural barriers when it's about environmental claims. So I was thinking when I was reading the advisory opinion, whether or not we also, the European Court or the UN treaty bodies, should also, endorse and take into account this need for reforming the procedural rules of admissibility, exhaustion of domestic remedies, and so on. And it's not a theoretical question, because you probably know that before the Council of Europe and the Committee of Ministers of the Council of Europe, there is this ongoing discussion on whether or not we should adopt a protocol on the right to a healthy environment. And this question of how to adapt the admissibility condition and so on was raised. So I really appreciate the development of the Inter-American Court on that. Of course, the third element that is very important in the advisory opinion is what the court said about nature, and nature as a subject of rights. And I'm quoting the court. She said, yeah, it's not alien to the Inter-American corpus juris, but rather represents a contemporary expression of the principle of interdependence between human rights and environment. And again, she has a lot of development on what it means concretely. It's not just a theoretical question, it's not just a question for academics, but what it would mean to have nature as subject of rights and legal personality and so on and so forth. And for the court, it's also related to states' obligation based on the American Convention. So these developments by the Inter-American Court were really, for me, are really important, and they should be developed. Two final points on the substance I really I wanted to highlight. What she said about the relationship between democracy and climate change or climate emergency and so on. And of course, here for a human rights lawyer, it was a part that was very familiar to me, because it has to do with the right to participate, the right to freedom of expression, the right to peaceful protest, and so on. But it was interesting also to have all this development on the protection of environmental defenders, because what we see in the world is that more and more, and in many countries, there is a criminalization of the climate discourse or climate protest. So it's not just a sort of climate skepticism, but we have more and more the use of force, excessive use of force when dealing with protest in favor of climate movement and so on and so forth. And the court really insisted on the fact that there is a link. So when we talk about environment and climate change, it's not only a sort of economic, social, and cultural rights issue, but it has to do also with democracy. And this triggers a lot of very traditional, I would say, states' obligation again to grant an access to everyone to the decision-making process and so on and so forth. And final point, that was also very interesting, what the court said about right to science, right to access to traditional knowledge. And here, of course, again, the court has a very strong jurisprudence on the rights of on the rights of indigenous peoples, but she really developed this aspect, and especially she really insists on the fact that when we talk about climate change, we talk about something very scientifically based. So there's no place for misinformation, fake information, skepticism, and so on and so forth. And this has also to do with democracy. So now, what would be the next step, and what are the perspectives in terms of implementation? Because when the advisory opinion was delivered, I read some comments saying, okay, but it's just an advisory opinion. I think Catalina actually already answered this question. First, and I go back to this point, the court insisted on the fact that, yeah, formally it's just an advisory opinion, but the interpretation provided is binding for all members of the Organization of American States, because it's an authoritative interpretation of the also the American Declaration on Human Rights and Duties, and also interpretation of the Charter of the Organization of American States. Binding, as I said, also for all the branches of a state, so government, executive branch, legislative, and the judiciary. I would like also to insist, and that's a big difference, I think, between, for instance, Europe I'm more familiar with, and Latin American countries. I would like also to insist that, on the fact that in many Latin American countries, actually, advisory opinions of the Inter-American Court are considered as binding. And they have the same legal status in the domestic order as the status of judgments of the Inter-American Court. So there's no difference between an advisory opinion and a judgment of the Inter-American Court. So I'm quite optimistic, actually, on this question. Final element, and that was said by Catalina, but we can see and we can read this in the whole advisory opinion. What we are talking about, it's really something is existential for most of Latin American countries, Caribbean countries, and so on. So they do not have the choice to implement or not implement the advisory opinion, because, and that's why I said it was important actually to have this request by states, because what we are talking about, it's not a problem that is, probably will occur in a couple of years. We are actually, in many countries, are suffering from the harmful consequences of climate change. And very recently, the Inter-American Commission delivered a very interesting report on Bolivia, for instance, and the problem of climate change, pollution, and environmental protection in Bolivia. So again, I'm optimistic because states are aware, I think, but I would be happy to hear from other colleagues, are aware that, again, they do not have the choice anymore to cooperate or not cooperate, to implement or not implement. It's not whether or not it's a binding document or not. It's really something that was that is existential, and that's why the court used a lot this vocabulary of climate emergency. So I agree with Catalina. I mean, the human rights language and the human rights discourse, for me, it's the most, probably today, the most powerful vector of advancing this climate change agenda. Thank you very much.
Thanks very much, Aline, for that very impactful and I feel very powerful statement from you. And there are many, many elements there. And I think one of the first things you talked about is also this idea of which also Catalina mentioned, the question of non-silos, the question of integration, particularly in the way and the method adopted by the court in looking at the sources of law and the entire international corpus of law in coming to its opinion, and the very powerful and impact use of the human language of human rights, in which I think lots to be unpacked further. From there, I'd like to move to Harry, and specifically from a fairly emotive issue to a separate issue, which also links, which I think Elizabeth will also speak on, where it impacts on corporate actors, and particularly in relation to economic law and investments. What comments do you have in that regard, given the urgency of this issue? It's a crisis, it's a climate, and yet the discussions on investment, reform, arbitration have taken a while, and it's still continuing. Over to you, Harry.
Right. So thank you very much, Danielle, and it's a pleasure to be here with all of you. So the advisory opinion, just trying to answer your questions, does not really contain a lot of explicit references to investment treaties, which is perhaps understandable given the nature of the opinion being a human rights opinion. But I think that the implications of those few references can be quite important for how states should proceed to take climate mitigation measures going forward, and also with respect to how they should proceed with investment treaty drafting in the future. So I want to sort of focus on three main points on the relevance of the Inter-American Court's opinion with respect to investment treaties in particular. So I want to talk about the context in which the opinion makes references to investment treaties, And then with respect to the court's suggestions as to the measures that states should be taking, I want to talk a little bit about what the implications of that are going to be with respect to the current investment treaty landscape. And then I want to close with really a flavor of the treaty drafting approaches and proposals that we currently see to help ensure that investment treaties are not an obstacle to climate action. So the first point, right? So the opinion conceptually locates the principal relevance of investment treaties against the backdrop of the right to a healthy environment and in the context of the state's obligations to mitigate the greenhouse gas emissions. So the opinion emphasizes that in light of states' duty of enhanced due diligence in their climate-related activities, that they must ensure a degree of policy and legal coherence. That is to say, they must ensure coherence between, on the one hand, their climate mitigation obligations, and on the other hand, their domestic and international commitments, in particular with respect to foreign investment and trade, and also finance. So with respect to investment treaties, at the outset, I would say the opinion takes a rather balanced view. So it warns, of course, that investment treaty obligations can be at odds with states' climate and environmental obligation, and warns very forcefully about the dangers of regulatory chill for states. But at the same time, it also acknowledges that this tension is not inherent and is not inevitable. So it seems to me the court recognizes that reformed investment treaty obligations can play a positive role, or at least they don't have to play a negative role in providing both protection to foreign investment, but also not obstructing climate action. So for the court, really, the real culprits, so to speak, seem to be states' regulatory design policies, so how they go about designing their investment treaties and their investment policies, and also the availability of investor-state dispute settlement. And in that respect, the court gives very clear guidance to states that they should review their existing investment agreements, and they should also review their investor-state dispute settlement mechanisms to which they may be subject, so as to ensure that they do not limit or restrict the efforts to mitigate the effects of climate change and fulfill their human rights obligations. Now, this brings me to my second point, which is I want to talk a little bit about what the opinion suggestions to states about the things that they should be doing to mitigate their emissions and respect the right to a healthy environment. What do these mean in terms of their investment for states' investment treaty commitments? And it is important here to keep in mind that investment treaties apply across wide areas of state regulation. And as is often the case with investment treaty claims, the devil is in the details. So my sense is that tribunals will rarely challenge directly a state's policy motivations and objectives in adopting a measure, if such a measure is adopted in good faith, but would rather point to procedural or other irregularities in the manner in which the measure is adopted or implemented against a particular investor. And so some of the suggestions made in the opinion to states can implicate investment protection standards. And I just have a couple of examples to mention that are inspired by the kinds of mitigation measures that the court encourages states to adopt. So of course, the principal duty is to minimize greenhouse gas emissions, which may involve banning high-emitting activities, phasing out fossil fuel extraction, for example. Now, I think even with the entire weight of the international climate change regime bearing on this scenario, it is still conceivable that an investment tribunal might find a state liable if, for example, the government of that state had made explicit promises or assurances to an investor at the time that the investment was made, which may very well predate the Paris Agreement, for example, that the challenge measure wouldn't be adopted, or if the government had substantially interfered with a contract that the investor has. And contracts are very commonly used in, for example, the extractive industries. Or just to take another example, again inspired from the opinion suggestion, suppose a state decides to adopt differential treatment between companies in the same or adjacent sectors on account of their emissions. Now, this could be at least a prima facie case for discrimination if some of the affected companies are mostly foreign-owned, whereas the companies that receive the more favorable treatment are mostly domestic. Now, I don't mean to suggest that in taking all of those measures, a state will for sure be in breach of its investment treaty commitments. But what I want to say is that a lot depends on how the state implements the measure how clear the measure's public justification is, and also much may depend on the tribunal's ultimate composition that will hear that case. And that is really the point that I want to make, is that there is an inherent uncertainty here and a difficulty to predict the interpretive approach that investment tribunals will take. So on the one hand, the opinion offers very important statements to support states' mitigation measures. For example, there's a very clear acknowledgement in the opinion that companies have obligations and responsibilities with respect to climate change and with respect to the impact that climate change has on human rights. And this is a statement that should be an important consideration when assessing and polluting investors', let's say, legitimate expectations of regulatory stability. And so while reading the opinion, one hopes that those important statements and also important statements one finds in the ICJ advisory opinion will be taken on board by investment tribunals when interpreting investment treaties. At the same time, one also hopes that states in adopting climate change measures in the future will do so after having done a careful audit of their investment treaty portfolios before acting, so as to try and determine where there may be potential litigation risks, and then take steps to try and minimize them to the extent possible. Which then brings me briefly to my third point, which is what is currently happening with investment treaty design that might help alleviate somewhat those risks. Now, investment treaty reform is not really a new thing. States have been iterating and reforming their investment treaty provisions for years, precisely to allow for more regulatory space for the public interest, including for environmental reasons. However, as you pointed out, Danielle, results have been rather mixed. And so for any one case that one can see where a tribunal may have used, let's say, a dedicated environmental provision in the treaty to inform the way that it interprets investment treaty standards, one can also see other cases that have interpreted exceptions provisions, for example, that were meant to safeguard the state's right to regulate in a way that is arguably depriving those provisions of any useful meaning. So what we see lately is attempts at incorporating climate action or climate action measures into investment treaty commitments. And this could be done in indirect ways sometimes. So for example, by issuing a joint interpretive statement, in a sense, instructing tribunals that investment treaty commitments should be interpreted in a manner that supports states' ability to meet their climate commitments. Or it could be done in a way of trying to limit the scope of application of certain investment treaty standards. For example, by limiting the scope of fair and equitable treatment, which is one of the two main investment protection standards, to apply only with respect to administrative and judicial treatment by the state and not with respect to general legislation. And that could potentially safeguard against coal phase-outs, for example, which are maybe more likely to be adopted through general legislation. Other ways may be a bit more direct. So, for example, you start to see instances where states are clarifying that non-discriminatory climate action measures do not constitute an indirect expropriation of an investment. That is to say that they do not constitute an indirect taking of the investment by the regulating state. And a last sort of proposal that has been floated is the climate change carve-out that would effectively preclude claims by foreign investors from arising in connection with climate change-related measures. There are still, however, open questions as to what the scope of such a carve-out would be, whether it would include any and all measures relating to climate commitments, or whether it would only cover climate action in certain types of sectors only, for example, fossil fuel investments only, but not others. So these are the kinds of things that I picked out from the opinion that I wanted to mention in my intervention. But I should say this is only really just a flavor of the many interesting issues that the opinion raises. And there are other references in the opinion that bear to some extent to investment treaty policies and investment treaty drafting, such as the obligations of corporations and access to justice that was also mentioned by Elaine earlier. But I think I should stop here, and perhaps we can pick some of those points later in the discussion. So thank you very much.
Thanks very much, Harry, for really honing in on the specific relationship and potential implication of the advisory opinion, particularly the area of investment law, investment reform, which is particular of interest not just to governments, but also to corporates and civil society as well. Climate change is a critically important sector, a pretty important issue, but at the same time, nations are also grappling with the need for social economic development. And this is where there is a lot of challenge in terms of accommodating and balancing both considerations. With that, can I turn to Elizabeth? And Harry talked about the potential implications for corporates as well, vis-a-vis investments, treaties and reform. And its advisory opinion did also talk about the government's obligation to really regulate the actions of corporates. What is the implication of this for corporates, in your opinion? And in this regard, I also refer to a question in the Q&A section that's specifically interested in this question. It talks about the legal opinion focusing on states' obligation and liability, but what is the thinking of the probative effect and impact on corporates apart from the immediate possibility of litigation suits and class action? So over to you, Elizabeth. Thank you.
Thanks so much, Danielle. It's such a pleasure to be taking part in this panel and really learning so much from everyone. So I would like to make my comments in respect of two particular types of corporate actors. The first is corporate actors who are located within the Organization of American States and the impact of the advisory opinion on them. And this follows on from Elaine's comments on the applicability of the advisory opinion to the Organization of American States in general. I'll refer to that as OAS. So that's one category of corporate actors. The second category of corporate actors would be those in non-member states of the OAS, and whether there are ripple effects of this advisory opinion on such states and more broadly on climate litigation. So just turning first to, I think, to the first category of corporate actors, it's really quite remarkable how this opinion goes into some specific detail to clarify and reinforce the duty of states in the OAS to regulate private actors, transforming what was maybe a matter of policy discretion into specific legal obligations. So to provide some examples of this, the first pertains to mandatory human rights and environmental due diligence. The opinion makes it quite clear that states must enact legislation that requires businesses to conduct human rights and environmental due diligence to identify and address human rights and environmental impacts, including climate change-related impacts across the entire value chain. So this goes way beyond voluntary corporate social responsibility initiatives, but means that companies should be legally required to identify, prevent, mitigate, and account for how their operations will impact human rights and the climate. And the opinion goes on to explain that such processes must be appropriate to the size, sector, and operating context of each enterprise and include domestic and international supply chains. So this is likely to affect group corporate behavior, particularly where corporations within the group are incorporated in OAS states. The second way in which the opinion is quite granular is with respect to increased calls for transparency and scrutiny. So the opinion calls on states to compel public and private companies to disclose crucial information, including their greenhouse gas emissions, the climate impacts of their projects, and the implementation of their due diligence processes. So this will empower communities, investors, and regulators to hold corporations accountable for their climate pledges and contributions to environmental harm because of an increased ecosystem of transparency. The third important aspect is the requirement for mandatory reduction of emissions. So states must require businesses to take measures to reduce such emissions and address their contributions to the climate and climate mitigation targets throughout their operations. And in particular, the specific mention of increased accountability for carbon majors. So the court has opined that states should establish differentiated obligations with regard to climate action based on the actual and historical contribution of business enterprises to climate change and impose stricter obligations on those whose activities are major sources of greenhouse gas emissions. And such obligations could relate, for instance, to operating conditions, tax burdens, contributions to just transition plans and strategies, and measures of adaptation or measures to address loss and damage. Another really interesting aspect of this opinion is the requirement for states to adopt a range of regulations to discourage greenwashing specifically, and also to discourage undue corporate influence, so corporate lobbying, for instance, in the political and regulatory domains which relate to climate change and climate carbon mitigation. And also states are required to support the actions of human rights defenders, and Helen has covered that already, and so I won't go into that. So I think overall, this heightens the risk of litigation domestically in OAS states. And I think also when you couple this with Elaine's comments on the impact that the opinion could have on the role of domestic courts and the needs for reforming procedural rules on admissibility and so on, as well as Elaine's comments on the court's explicit recognition of nature and its components as subjects of rights. So this moves beyond a purely human-centered legal framework. It'll be interesting to see what kind of additional litigation this could generate. So legal standing, for instance, to act on behalf of nature, in addition to the types of legal obligations and increased disclosure requirements, which themselves heighten the risk of, I would say, more plain vanilla climate litigation against corporates. So the second, I think, category of corporate actors that could potentially be affected by this opinion are those who are in non-OAS states. And this is because of the very far-reaching and very broad and in some ways very ambitious scope of this particular advisory opinion, which opens avenues for transnational litigation. So in my view, there are a number of groundbreaking aspects. So first, in what I think is quite a historic move, the court declared that the state obligation to prevent anthropogenic conduct which irreversibly harms the climate and the environment has attained the status of jus cogens. So this means that it is a peremptory norm of international law accepted by the entire international community from which no derogation is permitted. Now, while international law primarily binds states, the establishment of such a fundamental norm creates arguably a type of standard of conduct that increasingly applies to non-state actors, powerful ones especially. And this type of classification can strengthen the coalescing of a legal basis for holding corporations accountable, regardless of whether it's incorporated in a OAS or non-OAS state. And because such actions could violate the fundamental value of the international community. I note as well that the International Court of Justice in its recent advisory opinion did not go quite as far as the Inter-American Court of Human Rights. So perhaps this is an interesting element that can maybe be discussed in subsequent webinars or taken up by panelists. So I think also because of these developments, there could potentially be increased interest by non-OAS states to consider the international legal norms that are coalescing and which need to be incorporated into their own domestic regulation, and to have increased scrutiny on the overseas activities of their own multinational corporations to prevent human rights abuses and climate harm elsewhere. So this has the potential to accelerate the trend of mandatory human rights and environmental due diligence legislation in countries and affect the operations of their companies. I think overall, in terms of global climate litigation, the advisory opinion will certainly serve as a form of persuasive authority in courtrooms worldwide, and particularly given that it's possible to perhaps argue that there is a right to a healthy climate as a principle of international law and that corporations have a responsibility to respect it. And the manner in which the court conducted its legal analysis could perhaps serve as a blueprint for judges in other jurisdictions who are grappling with similar issues and may face cases such as this in a domestic context. I think the last point I'd like to make really is about shifting investor and insurer expectations. So the heightened legal risk for corporations that stem from this opinion, as well as other opinions and other global developments, will influence the decisions of investors, insurers, and financial institutions globally. Companies certainly with poor climate performance, regardless of their location, may face divestment, may face higher insurance premiums, greater difficulty in securing financing as the financial sector responds to the evolving legal landscape and the risks that are associated associated with climate-related litigation and increased regulatory changes. So I think Dr. Shara Lampos has already referred to investor expectations in relation to investment protection in international investment treaties. And this also, I think, is another aspect of the shift of expectations of investors and the manner in which now they may have to grapple very clearly with climate-related matters and sustainable development, as opposed to expecting, I think, the old regime of protection and without these particular new parameters in a heightened and new global regime. So I think overall, definitely this advisory opinion is, in my view, exciting and really historic. It's important, I think, for the private sector to be fully prepared for changing regulations. To address perhaps the question that was posed, I would say that corporations shouldn't be waiting for regulations to occur to then respond. It's really important to get ahead of the regulatory direction of travel, perhaps by implementing transition plans informed by best available science and considering risks in supply chain and operations across jurisdictions, as well as the legal risk and litigation risk in different jurisdictions. And I think the kind of pressures that can arise from this. And this is not just a matter of litigation really, but about being competitive in a new ecosystem of change. For civil society actors, I would also say that that civil society should have quite a close understanding of the international legal obligations of states and the manner in which domestic law should reflect this and advocate for action by corporates and regulators accordingly. And I would say that this advisory opinion certainly provides material for civil society to base the advocacy on, and also encourage advocacy between jurisdictions through civil society concerted action. So thank you. I think I will end my comments there and happy to take more questions.
Thanks, Elizabeth, for really bringing us the two equations, right? One is on states, and also the critically important and potentially far-reaching impact of this decision for corporates, not just, as I said, in Americas, but beyond, given how the advisory opinion was scoped. And I just picked up one or 2 points from your comments, which is quite important, quite interesting, and maybe I can invite Nilofer to also touch on this in her comments later. When you talked about the differentiated obligation for carbon majors, perhaps stricter obligations on those with major sources. Now, how would that adapt and how would that translate when we look back at the obligations in the Paris Agreement? And that would be an interesting perspective. So with that, Nilofer, last but certainly not least, may I invite you to provide your overview reflections, having heard what others have spoken. You have been involved in the important advisory opinion for IACtHR and ICJ, and although we have webinar 3 coming up, what is striking from the reflections and to end off our presentation? Thank you.
Thank you, Danielle. And first of all, I really appreciate very much you're putting together this trilogy of webinars. And I'm actually listened very intently to our excellent panelists. And I'm going to speak very briefly because I think they have really covered the core issues, and I can't add very much to these. But highlighting, I mean, I was struck by many things, particularly that Hélène said, and one that the court's insistence that the issue is a polycrisis. And I think that this is, I mean, to have the court say that is very important and stress that. And we see that we do need to break the silos without question. And in a sense, today we have as well. And the fact that the court looked at investment is very important. And that's one of the silos. And Harry touched on that. And this is something that CIL has been working on, and Harry as well. So between the human rights, breaking the silos, this climate, it is a climate urgency. We're all going to suffer from it. There's no living thing is going to be protected from climate change, frankly. And how this then impacts into this other area of private actors, including corporations. I'm going to pick up on just the one point, and as I said, I'm going to be brief, is use Kogan's. This really, and I know, Ellen, you were saying some of the progressive development issues, but even though Use Kogan's itself is part of the Vienna Convention of the Law of Treaties, the International Law Commission did a work on it. I was involved in it, and to be quite honest, it was one of my favorite topics. But to have it now put in the context of climate change and human rights, climate change overall, and to me, I personally am not surprised. I think that the time is approaching. But Harry, what this means for investment contracts, and some will say that I know that the court went too far, perhaps, but I'm not sure. If we keep talking about an existential crisis to all of living things in humanity, I mean, I don't know how much higher we can get for that threshold. So as provocative as it seems, it is in the Vienna Convention of the Law of Treaties. So will there come a time to apply this to some of these investment treaties that are problematic, or some of the actions by corporations? So that's a question I leave and something to talk about, because that is a game changer. Are we there yet? Probably many will hesitate, but I think I appreciate the court taking up that point. So I will stop here, and I think we can open the door for some questions. But I thank everyone also for their excellent presentations.
Thank you very much for this reflections, Nilofer. And I want to take this opportunity to perhaps invite the panelists to answer some of the questions that have already been listed. And that's one for you, Harry, on whether, and this is from Kersian, whether the existing investment treaty law and standards cover the situations mentioned. She's given a few examples, and I invite you to look at her question and to respond to that. Helene, there are, of course, many specific questions for you. One by Elvis Ongiri, who's a researcher based in Kenya, and asking about, given that the court had used a broad international law corpus in the judgment, is it a correct conclusion and argue that it didn't cause any fragmentation, especially in light of the other two advisory opinions? And secondly, the import of this decision on the request and final determination of a similar nature before the African Court of Human and People's Rights. And that, of course, is a little bit of crystal ball gazing, but what do you think the trajectory suggests to you? There's a general question at the beginning on nature of entitlements of inhabitants belong to low-lying deltas. I suppose this question is really more on the impact and implication of the decision beyond the OAS region specifically, perhaps in relation to climate refugees and things like that. And I would invite any panelists to respond to that question. So, Harry, would you like to start us off by responding to Kersian's question?
Sure, yeah. So it's a good question. And I mean, the premise is right. There's no reason to my mind that those situations I mentioned couldn't be addressed by existing investment treaty standards. That's why I said it's not the case that with absolute certainty the examples I mentioned would put a state into breach. The issue really is that we don't have a consistent certain line of case law here about how we should interpret those treaty standards. So yes, a good faith measure could preclude a breach of fair and equitable treatment. At the same time, you have tribunals that have looked at domestic laws and found out that they were worded in such a way that they could be interpreted as providing a guarantee of stability. Now, this is controversial, but it cannot be excluded that something like that could happen. Similarly, with the second example that Kersian mentions about whether different emission standards mean that the investors are not in like circumstances, which would preclude discrimination. Again, that is true, but again, we don't really have a very clear test about how to determine like circumstances. Different tribunals have taken different approaches. So it's really that uncertainty that's the issue, as I say it, at the moment. And that's why states are trying to put more. Now, with respect to Nilofer's question about investment contracts, I'm a bit hesitant to answer that fully. I mean, I think for investment contracts, a lot has to happen at the domestic level, because I think ultimately investment contracts would be governed by domestic laws. What we perhaps can do in the investment treaty space is change our perception about what it means to, how much of an interference with contractual rights would lead to a finding of expropriation. That's perhaps what we could change at the investment treaty level. I think otherwise a lot would have to happen at the domestic level.
Thanks, Harry. Your comments also touch on interplay between and ultimately the translation of the decision at the domestic level. That's an important point from your comments. Helene, may I come to you to address the question that's been posed? And we have a bit of time left, not too much, but I would invite any other comments, questions to be included in the Q&A function now. Helene, over to you, please.
Thank you, and thank you to Elvis for the two questions. So I will start by the second aspect of the question. Yeah, for sure. I have no doubt that this advisory opinion, but also the advisory opinion of the ICJ will be considered by the African Court when replying to the questions that are raised. And I mean, I guess that the advisory request will be admissible, I hope. Also because as you know, I mean, in the African Charter, we have this Article 24 on the collective right to a healthy environment. And to a certain extent, the African jurisprudence is already very well developed on the state's obligation. What Elizabeth also and Harry said about investment, private sectors, and so on, we have quite strong African courts jurisprudence. But I have no doubt that, because there's a good dialogue. When I say I have no doubt, it's also because the two courts actually dialogue and especially when dealing with very common issues. So yeah, I'm very confident in terms of impact and dialogues between the two courts. Regarding your first question, yes, for me, I do not see any fragmentation, and I have not seen, I would say, any contradiction, even when we talk about use cogens and so on, because what the court said, actually, the reason why now we have use cogens and this use cogens element when dealing with obligation not to harm, it's because also it's related to, I mean, the protection of the right to a healthy climate and the right to a healthy environment is related to the right to life and the right and protection of integrity. And she makes a direct connection between what she said in terms of link between environment and right to life and integrity in the first advisory opinion and what she's saying now in terms of use cogens. So it's even not a surprise, because we had in this previous advisory opinion the first step, I would say, in terms of recognition. So I do not see, again, fragmentation indeed. For me, it's really a part of this development and even an investment and use cogens. I mean, we have previous jurisprudence of the Inter-American Court, especially when there was it was a case with an issue in terms of investment and in contradiction with prohibition of slavery, and the court said, yeah, in prohibition of slavery, it's a use cogens norm. So in this case, I mean, it's impossible for a state, for instance, to engage in this kind of relation. So yeah, I have the impression that it's advisory opinion. It's a sort of, as I said, a sort of not final step, but yeah, harmonization of all its previous decisions, and not only its previous decision, but also other international decision. And she quotes a lot IACtHR's advisory opinion and regional decisions and UN materials and so on and so forth. So yeah, as Catalina said, it's really a universal decision, actually, not a regional one.
Thanks very much, Helene. I'm actually curious, Dilifat, if your views on this question. As I said, you've been involved in two of the advisory opinions, the IACtHR's and the ICJ. What are your thoughts on this question on fragmentation and system integration, and perhaps a little bit of crystal gazing as to what you hope to come out or see from the African court?
Well, actually, this is something I didn't comment on initially because I know we have a trilogy, but I appreciate the question because actually I think we're seeing integration, not fragmentation at all. And then you talked about the cooperation, which also featured very, very heavily in the ICJ advisory opinion and also IACtHR. So we see a lot of common threads. And so I suspect it will be the same with the African opinion as well. Differences, but they're not fragmentation. I wouldn't say that. And again, maybe when we talk later on, but since you asked the question, it was really notable in the ICJ advisory opinion with multiple references to the IACtHR advisory opinion and really giving, a great deal of a high endorsement to IACtHR. So I think that this is probably one of the, how do I say, unintended outcomes. We'll see this integrated solidification of international law through the courts on responsibility of states vis-a-vis climate change. And that, I don't think we can overstate the importance of that.
Thank you very much, Nilufer. We're almost out of time, and so I do not propose to summarize the very rich discussion that has taken place. This is recorded and will be available for viewing later. But before I end, I just wanted to give every panelist a chance to perhaps in one word indicate what this decision means in terms of significance to you. Just one word, roundtable, and then we'll close off the discussion. Okay, I see Nilufer thinking. Elizabeth, how about I start with you?
Okay, I
Just one
think
word, very quickly.
Sure. Granularity. So I think for me, this opinion was interesting in the specifics the detail that it went to with respect to what it expects states to do regarding regulation of corporates. And I think maybe in contrast to the ICJ-AO, this particular opinion had much more granularity in that and provides a template potentially.
Thank you. Okay, Harry, one word.
I would probably say groundbreaking. I was struck by the recognition of nature as a subject of rights, and I really appreciated the discussion on procedural rights. I thought that was a very good addition.
Helene?
I would say let's continue to break the silos. And that's what we are doing, because it's really, really important to keep this conversation.
Thank you. Nilufer. And Nilufer. Oh, you're muted.
Okay, maybe there's a reason, but impactful. One word.
Thank you very much. With that, let me thank all of you, and of course Catalina, who's not with us now, for a very important contribution to the discussion and discourse, which no doubt will continue into our webinar 2, which will take place on the 5th of August. So please look out for the flyers that will come up. And of course, our final in the trilogy, the webinar, we do not have a date yet, but we will collect and have a roundtable discussion on the impact of all the advisory opinions on what this means for the future of international legal governance and lawmaking. With that, good day, good night, wherever you are. Thank you very much for joining us, and see you next time.
Thank you, Danielle.
Thank you to everyone.
Thank
you.
you.
Thanks.